Tucked away in the U.S. Bill of Rights is one of the most debated phrases in all of American law: cruel and unusual punishments. We've all heard those words, right? But what do they actually mean? Today, we're going to unpack the Eighth Amendment, where this powerful and kind of ambiguous idea came from, and how its meaning is still being fought over in courtrooms right now.
To really get the Eighth Amendment, you have to start right here with this really powerful reminder from Justice Hugo Black. This isn't just some dusty 200-year-old relic. No, the questions it raises about justice, about power, and about basic human dignity, well, they're as relevant today as they were when the ink was still wet on the Constitution.
At its very core, the Eighth Amendment is about one simple thing: drawing a line in the sand. It's about limiting the most fundamental power any government has over its people. So let's explore why that is just so critical.
John Adams just cuts right to the heart of it here, doesn't he? I mean, the founders were obsessed with this idea of balancing power. They knew deep in their bones that a government without checks and balances always, inevitably, becomes tyrannical. And that fear is woven directly into the fabric of the Bill of Rights. So, all right, if the goal is to limit this state, where do you even start? What is the most raw, the most direct form of power that a government can possibly wield against a person? It's the power to punish, plain and simple. The ability to inflict pain, to take away your liberty, or even to take your life. For a democracy to even be a democracy, it absolutely must place strict limits on how, when, and to what extent it can punish its own citizens. Without that limit, that balance Adams was talking about, it's completely impossible. Okay, so the specific words cruel and unusual didn't just appear out of thin air. The founders were actually borrowing from a history they knew all too well, one that was just filled with the terrifying abuses of unchecked power. And you can see their inspiration perfectly right here. Just look at the language side by side. The Eighth Amendment is nearly a word-for-word copy of a clause from the English Bill of Rights of 1689. And that English law was a direct reaction to the monarchy's absolutely horrific punishments for even minor crimes. The founders wanted to make sure that that kind of state-sanctioned cruelty never, ever took root in America. But here is the central problem, the real head-scratcher. While the founders knew what they were afraid of, they weren't entirely clear on what they were actually prohibiting. In fact, one founder, Melanchthon Smith, complained that the phrase's meaning was just too indefinite. And boy, was he right. That ambiguity set the stage for centuries of debate. This quote from Samuel Livermore is, wow. It's just fascinating because it shows you how different their world was. To them, punishments like whipping or even mutilation were still on the table. They were literally asking if this new amendment would stop them from doing things we would consider absolutely barbaric today. It just goes to show that from the very beginning, the definition of cruel was a moving target. So since the founders left the term so incredibly vague, that difficult job of defining cruel and unusual has fallen to one body, the Supreme Court. And as we're about to see, the court's answer has changed, and I mean dramatically, over the last 200 years. So this gives us a bit of a roadmap of the key moments. You can really see the court's thinking shift over time, from declaring way back in 1910 that the amendment has to evolve, to pausing the entire death penalty in 1972, and then restarting it just 4 years later. Let's really focus on that wild back and forth over the most contentious issue of all, the death penalty. So in 1972, in the landmark case Furman v. Georgia, the Supreme Court did something truly stunning. It effectively paused the death penalty across the entire country, ruling that as it was being applied, it was unconstitutional. Now, the key here wasn't that execution itself was inherently cruel, but that its application was totally arbitrary and often discriminatory. Justice Potter Stewart captured the whole idea with this unforgettable line. He argued that the death penalty was being handed down so randomly, so freakishly, that it served no rational purpose anymore. It wasn't a tool of justice, he said. It was basically a terrifying lottery. But then, in this incredible reversal, just 4 years later, the same court changed its mind. In Gregg v. Georgia, it ruled that the death penalty could be constitutional, but only if states created new guidelines to make its application less random. And that decision allowed executions to resume, and, well, the debate has been raging ever since. Now, the death penalty gets all the headlines, right? But the fight over what's cruel and unusual goes far, far beyond capital punishment. The Eighth Amendment has been used to challenge a whole range of punishments and conditions inside the justice system. Take the 1958 case of Trop v. Dulles. A soldier was stripped of his U.S. citizenship as punishment for deserting during a war. So the Supreme Court had to decide, is making someone stateless, a person without a country, a cruel and unusual punishment?
The court's answer was pretty profound. Chief Justice Earl Warren wrote that losing your citizenship was the destruction of an individual's status in organized society, and it resulted in a fate more primitive than torture. It was a really powerful statement that cruelty is not just about physical pain.
And the amendment's reach just keeps expanding. It's been used to argue that prisoners have a right to basic medical care. It's been used to challenge the psychological toll of long-term solitary confinement. And it's even been used to question whether life sentences for non-violent crimes under things like three-strikes laws are proportional. So, what does all this tell us? Well, it reveals this central tension in how we interpret the Constitution. Is the Eighth Amendment some static rule frozen with its 1791 meaning, or is it a living principle that has to be reinterpreted by each new generation? Well, the Supreme Court has largely landed on the idea that it's a living thing. And this right here is the legal tool that makes that whole living document approach possible. The court's official test is whether a punishment offends the evolving standards of decency that mark the progress of a maturing society. Now, in simple terms, what that means is the definition of cruel isn't fixed. It actually changes as our society's own values and our own sense of decency change. Think back to that Samuel Livermore quote about whipping people and cutting off their ears. Punishments that were perfectly acceptable, even normal to the founders, are now universally seen as cruel and unusual. And that's not because the words in the Constitution changed, it's because we did. Our standards evolved. And that leaves us with a final, really challenging question. We look back at the past and we judge its punishments pretty harshly. So what about us? What common practices in our justice system today might be viewed by our children or our grandchildren as intolerably cruel and unusual? It's a question the Eighth Amendment forces every single generation to ask itself.